my pleasure to have the company of St John Heath. St John is a very experienced family law practitioner. He's an accredited Law Institute of Victoria Family Law Specialist and a director of Tonkin Legal Group, a leading family law practice based in Greensborough in Melbourne's north. St John, welcome.
Thank you, Sean.
So much of my work as a criminal defence lawyer involves defending allegations for an accused at court and mitigating their penalty. But where an allegation occurs in the context of family violence, it's more than just a criminal outcome that might be at stake. And so it's great to have you here today to talk to some of the more practical aspects of topics where the criminal law and family law converge.
And thanks, Sean. I was really happy to be a part of this because there are some crossover points, as you've pointed out.
Indeed, and perhaps we could begin with the stages of the intervention order proceedings in the Magistrates Court. Can you provide a bit of an overview of the process there from the moment a respondent receives an intervention order and the way that those proceedings come to an end or resolve?
Certainly, and as we've discovered with the pandemic, everything's been stretched out as well. So unfortunately, that process was always very long, but has now become even longer. So often the application these days is made by the police. The respondent is served with a copy, or the person who's been accused of committing family violence is served with an intervention order, usually by the police, where they will quickly explain the nature of that order and ask them to either vacate the home or not attend there any further. The matter's then listed, usually in about 2 to 3 weeks from the date of service, and it's listed for a mention only. And we always get those notices of hearing forms that say your matter is listed for mention and it's listed for 5 minutes. So often we have to explain to clients that it's not a day in which they'll walk into the court where the magistrate is sitting there and just hearing their case. It's a mention really for the court to decide where the matter needs to go next, and or it's an opportunity obviously to resolve the matter, but generally it's not what the client expects, and unfortunately any order that's been previously made will be extended on that day, which is frustrating from the client's perspective.
Indeed, and I think that the point you make about the court having a very limited amount of space at that first mention is an important one. It's not always possible to put forward a full defence of the allegations that are contained in that narrative that a respondent receives. But where there is a dispute, all the same, what happens after that first mention? Where does the case go from there?
Well, there's generally a number of mentions and a directions hearing and ultimately a final hearing. And that final hearing is when each party gives evidence and a court decides whether or not the evidence is sufficient enough to uphold an extended or permanent intervention order. And my experience from start to finish can be well in excess of 12 months. And that's concerning for a client because they don't really get an opportunity as a respondent to put their evidence before the court or to put their case really until that final hearing.
Yes.
And that's frustrating.
Indeed. And it's also the case that in those periods between a mention to a directions hearing where there are matters in dispute and where the matter perhaps can't resolve, that the court may order an interim order. So what's if you could just perhaps explain what how an interim order works and how that can also influence, if indeed it does, the way that a matter might resolve.
Well, an interim order is obviously an order that's made in the meantime. So between now and the end of the matter, the court will often make interim orders, and that imposes the terms, if you like, or the impositions of a final order, but on an interim basis only, which can restrict, obviously, people's civil liberties and their right of movement, can affect their capacity to spend time with their children, and other factors like that. So an interim order, albeit an interim order, has the effect really of a final order. They're the same terms in most cases.
And is it the case, in your experience, that from start to finish, and you may have mentioned this earlier, that the matter can proceed from a mention, and as you've indicated, in those periods between court events, an interim order may be effectively rolled over from one court date to the next, so that is it the case that at a final hearing, as you've indicated, some 18 months away, a respondent may be subject to interim orders for that period of time?
Correct, and that's generally my experience. Because the court literally doesn't have the time to hear the matter in its entirety, each individual court event leading up to the final hearing, the interim order is just extended. So technically you can be in a system for about 18 months, never have the opportunity to put your case, yet the interim order is continued, and with the same terms generally, and in effect you've had an intervention order for 12 to 18 months without the court ever testing the evidence.
And when a case gets to that final stage for a contested hearing of the application, what test does the court apply in determining whether a final order for a family violence intervention order should be made or not?
Well, generally the court has a twofold responsibility, and that is A, to establish whether or not family violence did occur, and whether family violence was likely to occur in the future. And the test from a legal perspective is the balance of probabilities. And it doesn't take much, given the very, very broad definition of family violence in the state legislation. It doesn't take much for the court to find, A, there's been family violence, and B, there may be family violence in the future. Of course, we're talking about family violence in a broad context, but it can include emotional violence, economic violence or economic abuse, preventing someone's access to a bank account, for argument's sake. So it doesn't just center on physical violence. It can be emotional, psychological, and economic, which is often the case. Well, often intervention orders have a flavour of all of that, in that they have many of those factors in the definition of family violence, which are alive and kicking in each matter. So, yeah, I don't know if that answers your question, Sean.
It does, St. John. And for respondents then that may be facing that sort of a time frame, it may be as long as 18 months. There may be interim orders that are rolled from one court date to the next. There may be issues regarding a respondent's access to their children during that period of time. What are the options a respondent then has to resolve a matter and potentially avoid a much longer duration of contested proceedings in the intervention order court?
Great question, and I get asked this question a lot. I have a lot of clients who will attend at my office having just had an interim order served upon them, and they're very upset about it. There's been some allegations raised against them which are very hurtful. Often they're very angry and they want to fight the matter to the end. I actually then sit them down and say, listen, fighting this matter to the end may not be your best option. One of the preferred options in my case, and not every situation will require this type of outcome or demand this outcome, but is to discuss with the client the concept of consenting to the order without admissions. So an allegation's been made, whether that be by the police or by the other individual or other party, that information is denied by my client. But at the end of the day, my view is it may be possible for them to consent to an order without admission. So they're not admitting to any of the allegations that have been raised against them. But more importantly, if the order starts on day one, that 5-minute hearing, which is called the directions hearing, you consent to the order then without admissions. It's listed on the bottom of the court order. Joe Bloggs consented to this order without admissions. Then the clock starts ticking from that day. So if it's a 12-month order, it starts ticking down from that day. If you want to run your case from start to finish, you run the risk of having a 12 to 18 month waiting period, and then potentially another 12 months if the court finds that the evidence of family violence is there and that they're going to make a permanent order. And of course, as you know, Sean, the court has the power to make an indefinite order, so it could be for 1 year, 2 years, or indefinitely. So I think there's some merit in getting up front, getting on the front foot with these matters. Yes, you have to consent to the order, so you have to abide by the terms of that order, but with that little notation down the bottom saying without admissions, I think that has it has impacts in the family court jurisdiction, and it also means that the order is starting to tick down day by day from that point, not from 18 months later.
Indeed, indeed. And as you've indicated, if the unsuccessful respondent at a contested hearing can't then say, well, I have been on an order for 18 months. Can I have the credit of that 18 months? Can it be deducted from a length of the final order? That's not an automatic or an automatic entitlement, and it probably rarely happens in any event.
It does, I think, and look, magistrates have discretion in that regard, as you're aware of, but my view is that if you test the evidence and you're unsuccessful at a final hearing, which you've taken 18 months to wait for, and you're unsuccessful and you lose, then the court's more than likely to at least set another 12-month order, which would be very frustrating and leave a very sour taste in your mouth if you then had almost 2.5 years of an order when you could have dealt with it on day one and at least had the record show that you had consented to that order without admissions.
Yes. One of the things that, as a criminal lawyer, that I'm always mindful of in discussing whether a client should contest an intervention order application all the way to that final stage of a contested hearing is the danger or the prejudice that an adverse finding of family violence may have. And given that the intervention order proceedings are recorded, like many other hearings in the Magistrates Court, there's always that concern from a criminal law perspective that recorded evidence might be used to buttress a prosecution against a client, and they might be in a worse position because of evidence that's unfolded and allegations that have arisen during the running of the hearing. But there's also that aspect of what impact a finding of family violence has, I suppose, in a family law proceeding. And I wonder if you could, based on your experience, and obviously cases will differ, but provide any insight as to the impact of a finding of family violence at the end of a contested hearing, as opposed to, as you've previously mentioned, consenting without admission. In both cases, there's a final order, but the means of getting there is quite different. And I wonder if I could get your thoughts on that.
Sure. Well, certainly the Family Law Act does take this into account. And in fact, there's a section of the Act that says a court is able to take into account any findings made in another court. So if you run the gauntlet through to a final hearing on your intervention order and you're unsuccessful, that's going to reflect negatively in the family court or the Federal Circuit Court. If you choose to make the order or consent to the order without admissions, then the negative feedback or the negative impact of that is greatly lessened, in my experience. So although there'll be allegations of family violence in any material filed with the family court, you can always say, well, I consented to that order, but I certainly didn't admit to any of those allegations. So running the gauntlet through the Magistrates Court, getting a bad result or not succeeding in having the intervention order struck out would impact negatively on you in the family court.
Yes, all right. And you mentioned earlier, or you may have mentioned earlier, there can be exceptions that can be made on an intervention order that provide a continuation of childcare arrangements. Could you provide a little bit more information on how that operates with regards when there's no
Sure.
family court orders in place, but there's an intervention order between two people?
Sure. So there's a common misconception amongst most people, and that is that if an intervention order is granted, it automatically stops you from seeing your children. And quite clear, that's what it says on the order. But there is a little paragraph on most orders, usually paragraph 9, that says exceptions. And generally under that heading, it provides for the party who has the order against them to be able to contact the parent of their children by either text or email, or through a lawyer or through a mediator. It also provides for the parties to attend counselling or mediation, notwithstanding that there's an order in place. So there's still an order there, but they have these exceptions which allow them to do this. It also says generally that you're able to continue to spend time with your children if there's a Family Law Act order, i.e. a family court order for parenting, a child protection order, or a written agreement between the parties. So if an intervention order has been granted against you and there are these exceptions that apply, then you can write to the other person and try and broker a deal or an arrangement for you to spend time with the children. I'd recommend that you probably do that with a solicitor, because it can be a bit of a minefield. And you don't want to step outside the bounds of the order or the exceptions, which may lead to a potential breach of that order. But in short, an intervention order doesn't usually prevent you from spending time with your children, notwithstanding that it says you can't be within 200 metres of them. The exception is that if you wish to spend time with them, you need to do so by way of a written agreement or a family court order.
Thank you, St. John. And where that process commences and there's some attempt to broker a workable childcare agreement between the parties, but for whatever reason it falls down, or one party just simply isn't or doesn't want to cooperate in that process or participate in that process, what is the next step for a party, a respondent, who wants to formalise an arrangement where there's frequency of contact, where there's some certainty as to the occasions that they're able to have perhaps contact or of their children? How does that? What's the next step there?
Yeah, that's a tough one, because your options are limited. And really, your options are limited to issuing an application in the Family Court or the Federal Circuit Court for what's called a parenting order, which would set out the arrangements that you're seeking to spend time with the children. It's not unusual for someone to take out an intervention order, for the person who's had that order taken out on them to contact that person to try and negotiate an arrangement regarding the children, just for that person to say, sorry, not interested. So unfortunately, if they're not interested in coming to a mutual arrangement, you would be forced to issue proceedings for parenting orders in the Family Court or the Federal Circuit Court. That can take some time. You can make urgent applications, but a parent not spending time with their children is not usually considered to be urgent. And the wait time between issuing an application for a parenting order and getting some time before the court's generally about 8 to 12 weeks.
Yes.
So it can be a significant delay. So if the situation does present itself, time is of the essence, and I think you should immediately file an application in the Family Court. It also gives you a little bit more power to then go back to the other party and say, there's a court matter on the horizon. Would you like to reconsider your position? Can we come to some arrangement regarding the children?
Okay. All right. Well, some good advice there. Do you have any practical tips, or what should perhaps a person who's responding to an intervention order, they have children, there are going to be difficulties moving forward. potentially. Do you have any practical tips as to what they should turn their mind to enhance an outcome for them as early as possible?
Well, I think, are you talking about someone who's had an intervention order placed on them and there's going to be a delay between them spending time with the children?
That's right, yes.
Look, I'm a great advocate for people doing courses. And that might be an anger management course. Even if you don't believe you have an anger management issue, go away and do an anger management course. It's not going to kill you. And it's something that you can use as evidence later on to say, look, there's been an allegation made against me. I've done an anger management course. I'm addressing that issue. And that would put you in a much better position, certainly in the family court, and I would have thought in the Magistrates Court as well, when the matter comes back on. There are so many different courses that you can do. There's parenting after separation courses, which deal with how to communicate with your ex-partner or former partner about children's issues. It gives you strategies to deal with relationship issues, especially when there's an intervention order in place. So parenting after separation is another good course. Even getting your own counselling. So if you're feeling under duress or pressure from the scenario, have a chat with a psychologist, speak with a counsellor. They might be able to give you strategies to communicate better with your ex-partner or your former partner and to get yourself right. So if you're not right, then you're not going to be presenting properly. So self-help is a great cure in these sort of matters. So go away, do your homework, do some courses, and then present back with those in hand. And it makes it very difficult for the other side to continue their argument.
Indeed, indeed. Well, look, St John, thank you so much for your time today.